Hello and welcome to Farm Business Bites. My name is Neil Butler. This is an introductory video to the series, and today we're going to be talking about succession, the importance of succession planning, and also the kind of structures that your business might have in place. Now, you don't want to hear from me, you want to hear from an expert. And I'm going to read this introduction because it's really important that we get it right. Today, we're going to meet Sarah Murray. Now, Sarah grew up in Queenscliff in Victoria and completed her Bachelor of Arts and Laws at Deakin University in Geelong. She was admitted to practice as a lawyer in 2013 and has practiced exclusively in the area of succession planning and deceased estates. Sarah worked at Geelong's largest law firm for over 10 years and then worked at Deakin University, where she developed the succession law unit and lectured. Sarah has recently joined Mast Lawyers in North Geelong, where she assists clients, including family businesses and farming families, on their succession issues. Sarah enjoys working with clients from all different backgrounds and aims to provide clear and pragmatic advice. In her spare time, she enjoys running, spending time at the beach with her dog Macy, and travelling to destinations in the Mediterranean. Welcome to our conversation, Sarah.
Thank you, Neil. Thanks for having me.
Sounds like you're a lot busier outside of work than you are at work, with running and traveling and dogs and all sorts of things.
Yeah, it's hard to fit it all in.
Isn't it?
But yes, I enjoy having the downtime from work, being able to get out, exercise or travel.
Yeah, absolutely. Well, today we're going to talk about succession planning, the importance of succession planning. I guess a good starting point, as any, is what do we mean by succession planning?
Yeah, so that's a good question. And actually, a lot of people don't really understand what that means. So when we talk about succession planning, it's quite a broad term and it can mean a number of things. But in its broadest sense, it's putting in place arrangements for the transfer and control of assets and other entities such as trusts and companies. And usually that's about when that happens is when you die, or it could be upon retirement. So today we're going to be looking at succession planning with a point of view of farming families, but effectively that succession planning is something everyone needs to do, but it is a little bit more involved, particularly for farming families. There's a bit more to consider.
In the last year or two, there's been a television series called Succession, which is very much based on a business. Is succession planning only about business assets or personal assets as well?
It's about both, Neil. So, and that's where it can be complex. So today we're going to run through just identifying, when we talk about assets, are they assets that are owned by you personally, your spouse, maybe you and your spouse together jointly, or are they owned as business assets? And is the business run through maybe a company structure or a trust? So we need to break that down. The first part of succession planning is always around figuring out, well, what are the assets that we're talking about that we want to deal with and that we want to transfer to beneficiaries? And what I wanted to discuss first before we go into the actual process of what might be involved with succession planning is just talking about the different types of structures that people might have in place and how those structures operate.
Is this different to estate planning? Because that's another term a lot of people would have heard in the past.
It's the same thing. So estate planning, succession planning, it really means the same thing. As we're basically just talking about whatever you own and your other business entities and how you want those assets and entities to be transferred when you're no longer around.
Is it just a flash word for will?
Well, it's not just the will, but it certainly includes the will. There's usually other documents that are involved as well, so I'll touch on that a bit later. But primarily you do need the will as a starting point. But one thing I will talk about as we go into the different types of assets and structures, the will can't cover everything. So I'll touch on that. So perhaps if I start off just reiterating, succession planning in this sort of modern day and age is really important for everyone, but it is really important in particular for farming families and businesses to really take the time and do it thoroughly. And that usually means getting advice from experts to do that, because it's often everyone's different. Everyone's got their own different family setup, but we tend to find that farming families are more complex for succession planning purposes than, for example, perhaps someone that's not a farmer that just, teaches that have their assets that are owned all in their own name, and they may have a very straightforward succession plan.
So the old one size fits all doesn't seem to be appropriate at this stage.
Nope. Everyone's
one size
unique.
fits one.
Everyone's getting a unique succession plan. That's what
Excellent.
we say. So if I start off with, let's identify, we always start with that. Whenever we're dealing with clients, we ask them, what are your assets? And that might be a little bit of an abrupt question for someone to ask, but we really need to know that so we can get a picture of how the assets are owned and how we can best deal with them, whether it's through the will or whether it's through other documents and other planning methods. So you might own your home, land, money in bank accounts, shares, superannuation. Farming families, you'll have the farming land, you'll have the plant and equipment, you'll have the stock. So it's identifying all of those assets. Then we usually like to break it up into, well, what are the actual farm assets and what are the non-farm assets? There might be the apartment in Noosa, the holiday house, or then there's the huge, acreage that's where all the farming's done. And who owns those assets? So when we say who owns them, is it you in your personal name? Is it you jointly with someone else, like your spouse? Or is it perhaps owned by a company, a private company that's been set up, or a discretionary trust, or what we call a family trust that's been set up? And I will talk about companies and trusts in a moment, but yeah, that's the first step. Is we want to be able to figure out what are the assets and who owns those assets. Sometimes we even have to do some digging. The client might not know that off the top of their head, that they might have such a big business that they rely a lot on their accountant to keep records of that, of actually what is owned by the trust or the company or in their personal name. Or we might even have to make some searches ourselves when we're dealing with land, doing some title searches just to make sure we know who actually owns that land.
I would have thought that some of those ownership questions might come up in a situation where farms have purchased other farms, and there's been different levels of the family, and all those sorts of things just make that level of complexity in the farming industry just that little bit harder.
Yeah, that's right. So it is best to be thorough with these things and to not just have a guess, because many a time clients have thought a property was held in their name when it actually wasn't. It was held in their spouse's name, or it was actually in joint names, or it was actually owned by the trust. So that's where we start before we can get into actually structuring the succession plan for them.
So all of those assets that you've referred to, farms, farm equipment, shares, superannuation, money, all that sort of stuff, are physical assets. Does it also include assets that you can't actually hold, like non-tangible assets, or any of those sorts of things involved?
So when you talk about non-tangible assets, what might you be thinking about?
I guess ideas, copyrights, those sorts of things.
Yeah, if those are owned, we'd want to know about them. That doesn't actually, we don't actually have that come up too often, but if someone does have, you know, trademarks or intellectual property in something, that is also something that can be owned and should be dealt with in the succession plan about who gets ownership of that if you die.
So in the context of today's conversation, though, we're predominantly talking about the things that are in your shed, the things that are in your house, the things that are in your bank account, those sorts of things.
That's it, exactly.
Yeah. Good.
So if I start off with the first one, the easiest one is the most common way of ownership is you own it yourself in your own name. So it's very common. Everyone would have a bank account in their own name. You know, you own your car perhaps in your own name. Many people own property in their own name. That's anything that you own personally. That's what can be gifted in your will. So you can do whatever you like with those assets during your lifetime. You can buy, sell, give them away, but your will only operate and basically apply to those assets that you own at the time of your death. So that's two kind of basic points, but pretty important points to understand. And then that's when we get into this distinction about is the asset jointly owned with someone else? So many people will own assets jointly with their spouse. That's probably the most common type of joint ownership. You can also co-own property or other assets with other people, but it's typically we see it coming up with spouses. They'll own their home together, and they might have joint bank accounts. They might even have shares held in joint names. But people need to understand that the will, surprisingly, doesn't actually cover joint assets. So if you were to die and you had some assets that were jointly owned with another person, your will not deal with them. Those assets will automatically pass to the joint owner, and that's called the rule of survivorship. So it's
most common example of that, I guess, would be the family home.
That's right. So for a lot of couples that might have a very simple setup where they just own, and this is not a farming family, but if they just own their home, have a couple of bank accounts together and superannuation, their will in the first instance when one of them dies won't really make a huge difference. Everything will transfer by way of survivorship, but they still always need that will in place for in the event, you know, if both of them died, or it also just adds certain clarity about who is the executor of their estate. But that's something that a lot of people don't quite understand, that if it's an asset in joint names, doesn't matter what you have about it in your will, it will automatically go to the joint owner.
Okay.
The other point to make is with properties, you can own a property as joint proprietors. So as I was talking about before, if you die, it will automatically pass to the surviving joint owner or owners. Or you can elect to own that property as a tenant in common. And that phrase means rather than, and you can elect how much that is. So it might be as tenants in common in equal shares. So you own 50% of the property and the other person owns the other 50%, or it could be in unequal shares. So maybe you own a third and another person owns a third and another person owns another third or 2/3. But effectively what you can do is if it's owned as tenants in common, your share of the property, your interest in that property can be gifted in your will. So that's a very important difference with when people are co-owning property. How is it owned? Is it as joint proprietors or is it as a tenants in common arrangement?
So in that situation, I'm a part owner of a home. I have purchased a house with my partner. If I wanted to make it a tenants in common, do I do that at the time of purchase, or is that something that happens after the event?
Yes, look, it's typically done at the time of purchase. That's something you should talk to your conveyancer about. before settlement, making sure that that is set up in the way that you want it to be set up. Most of the time, the default is just joint proprietors. So, and a lot of people, when they're purchasing, don't quite understand the distinction. So it will just, the property will usually get set up that way. If it does start that way, you can always change the manner of holding, we call it, later down the track. And that can be simply done. It's just a transfer. A solicitor or conveyancer can help you with that, and it's not a costly exercise, and it can be sometimes quite a very worthwhile exercise if you need to get it in the right way for the purposes of succession planning.
Yeah. Okay, so that's a reasonably common experience, I would have thought, for many people who are listening or watching this video. So I guess then we step into some of the more complex structures that are around.
Yeah. Okay, so not everyone will own a private company. That's the next type of structure I want to talk to you about, because they are anyone running a business will a lot of people are leaning into that at the moment as a structure. The benefit of a company is that it's a separate legal entity from yourself. So it's almost like the company is a person in a way, and that means that the company owns assets rather than you owning those assets. So the company assets are separate from your personal assets. A lot of people, though, in businesses who have companies set up tend to still sort of classify the company's assets as their assets, which is true in a way, but from a legal point of view, they need to understand that, well, anything owned by the company is actually the company's, and it can't be gifted in your will. That's an important point. It then comes down to, though, that ownership of the company, and ownership of the company is through, there's always shares in a company, and if you own shares in that company, you're effectively owning the company and therefore the assets that are held by that company. So in a will, you can certainly gift your shares in the company, and that's something, again, we would be looking at, making sure we check, we have a good understanding. We might have to do a search to check if you have a private company set up, we would want to check who are the directors of that company and who are the shareholders of that company, and make sure how many shares there are that a person has. So directors of the company, they manage the company, and shareholders, as I said before, they own the company, but they might not be involved in the actual day-to-day operations. Often you might be a shareholder and a director, but you don't necessarily have to be both.
Yeah. So in a lot of small businesses, and I run a small business and I have a company set up, I am the sole director and own all 12 shares. So I suspect, whilst it appears that it's me, it is really my business, but I could, for example, gift my shares to someone else at my passing.
That's right. Yeah, exactly right, Neil. So that's a perfect example of if you're wanting to pass on control of that company when you die, it would be through the shares, gifting the shares.
And there would be a lot of people listening, watching, who do have their own small business that fit in exactly into that category, where they've set up a company to run their farm or to run a retail store in a small store in a country town somewhere, who they would want to pass that on to their family and can do so. And I guess having 12 shares is a really good number because you can split it between 2 or 3 or 4 people evenly, and that's a really handy thing. I didn't realise that when I've just thought of that. Yeah,
that's exactly right. So, and often, when these structures getting set up by usually your accountant or your lawyer at the time, you're never looking at it from a succession planning point of view. That it's more focus is on the business, getting this entity set up to get this business operating, and it's funny because people never think about it at that time, and it is often a bit of a learning curve when people come in to do the succession planning, understanding, I have a private company set up, but I don't actually own those assets. I can't just have that asset in the company. I need to gift the shares. That's how it all works. So we do have to do a lot of education, I guess, when we're doing the succession planning, about just explaining the difference there.
Okay.
Yeah, so the next one I wanted to talk about that comes up a bit in businesses and farming families are trusts, and they're called discretionary trusts, or otherwise known as family trusts. So look, many people have never heard of trusts and find it quite a weird concept. And if some people do have trusts set up for their business, even they will confess that they don't understand it. They don't understand how it works. So I'll try to explain this as simply as I can, but do not worry if you're still scratching your head after this. Basically, the concept is you have a trustee who holds property. And when I say property, I'm talking about assets again. So it could be real estate, shares in other companies, bank accounts, cash in those bank accounts. And they're holding those assets for the benefit of a number of beneficiaries. You'll have a person called the settler, who is usually an accountant or lawyer that just provides an initial $20 to set up the trust. And then you have what's called the trustee, who is either a person or multiple people, or it could be a corporate trustee, which is a company. They are the actual legal owner of the trust assets, and they have the responsibility for administering that trust and the property in it. You'll also have an appointor whose role is really they just sit on the sidelines, but they have the power to remove and appoint new trustees. So by virtue of having that power, if they can pick and choose who's the trustee, whose job is to manage the trust, they effectively have the ultimate control of the trust. And these beneficiaries we talk about, they're usually a wide class of people. So it could be you and your family, so you, your spouse and your kids, but it can also extend out to much broader beneficiaries, relatives. It could include your grandchildren, parents, siblings, that sort of thing, and other entities that could be related to you. So that's the concept of a trust. And the other last point is they last for 80 years. So they run for quite a while, but at the end of it, they do have to vest. And there's usually specifications. There's a trust deed which sets out what happens when the trust vests, what happens to the assets, if there's any remaining.
Question without notice. I have seen on lots of invoices where businesses say, XYZ Proprietary Limited, as trustee for, sometimes it's a unit trust, sometimes it's a family trust. There's probably others. Are they all the same kind of thing, or the different trust types have different legs?
Yes. So there are different trusts. Unit trusts are different to family trusts, and I'm not going to go into unit trusts too much today, but they are slightly different. But unit trusts really are about there's certain units that everyone owns in it. Okay. Whereas if we talk about the family trust or the discretionary trust, it's the same thing when I say that. That's because it's discretionary, it means there's this class of beneficiaries and no one's got a fixed entitlement. It's ultimately up to the trustee to decide each year, how much they of the income from the trust and the capital assets that they will distribute to the beneficiaries. So they can pick and choose. And the benefit of that people see is that you can distribute in the most tax effective manner. So there's some tax advantages there. There's also asset protection because the assets are held by the trust and not in your name. So if you're someone that could be exposed to creditors, you're in business and it could be risky taking on liabilities, that sort of thing, it can be an asset protection for you. Also, people in this day and age are quite aware of family, like marital breakdown, and not wanting assets to be exposed in the event of a relationship breakdown and having to go through a property settlement and have assets split up. It can be another way of protecting assets from that.
Okay. Yep.
The other thing about, just one last thing to say about trusts, and this is important, is the problem with them is the assets are owned by the trust, so therefore not by you personally, and they can't be gifted through your will. So this often causes big headaches for the clients. They come in and they may have, through their advisors, their accountants, dumped a lot of their assets and wealth into trusts. And then suddenly the question is, well, how do we deal with it if we die? Who will get those assets? And we say to them, well, your will can't deal with it because you don't own it. So that's a big problem. And the way that we handle that is dealing with the control of who is trustee and appointer, and particularly who will be the appointer of that trust if you die. Because often if you've set it up, you'll be the appointer, you'll be in charge. But what happens when you die? We want to make sure there's something in place there. And that's where we can do what's called deeds of appointment to sit alongside your will to say, well, if I die, I'm appointing this person and this person to be appointors of my trust. And therefore, they'll be able to control it and they'll be able to administer it in the way you wish and in sort of in accordance with how you'd want if you were able to gift those assets in your will.
Okay.
Yeah, thanks.
Now, before we start talking about the succession planning journey, there's another type of business structure that I've heard of, and I'd be interested to get your head around what that is, and that is a partnership.
Yeah, so partnerships, they are, again, some farming families have set up through partnerships, and that's okay. That's a more simple way of setting up a business. It's usually in association with one or more, with two or more people, and it can be a less expensive way really to set up compared to having a company set up or a trust. The thing is, though, it's not a separate legal entity. So the partners in that partnership, they own those assets in the partnership. And so it is different to what I was saying before, that the company owns the assets and the trustee owns the assets in the trust. What needs to be in place with a partnership and what should be in place is a partnership agreement, and that will set out what are the arrangements, what's to happen if one of the partners dies or they want to exit, how can a new partner be appointed, and how should disputes be resolved. So it's pretty important. If you want to run like that with a partnership, should have a partnership agreement in place. Again, with partnerships, they can split the income that's made between the partners in whatever way they wish. But the disadvantage of it is that the partners are personally liable for the business debt. So that's why a lot of people want to steer away from that.
Okay. And apart from the individual ownership that we spoke about earlier, partnerships, sole traders, companies, trusts, all of those need to be registered and have an Australian business number, an ABN. Is that correct?
Well, a company will have an ACN. So yeah, again, that's probably going out a little bit of my expertise with what exactly every entity needs. But yeah, there'll be different reporting requirements depending on whether you're a sole trader, a partnership, a company, or a trust. So,
Yep. Okay.
yeah, and that's where, again, you have to be working with your accountant to make sure that the appropriate tax returns are getting lodged and the right records are being kept and updated.
Yeah, there's a bit of a theme I think will come through this, and that is don't try and do this by yourself. Get some advice from people who know what they're talking about, sounds a bit to me.
That's right.
Okay.
So yeah, did you want to, well, if now that we've done a little bit of a run through of, ownership of assets and the different types of structures, and hopefully everyone has a little bit of a better understanding that it's not that straightforward, that you can't just leave everything in your will. I wanted to talk a little bit about how we start this whole succession planning process, because a lot of people find it a bit daunting. It can all be a bit too hard sometimes. It can seem, it's too messy, and just not knowing where to start. So
it's also a little bit confronting too. That
exactly,
the only reason you really need this is you're going to die. It's not really happy days, is it, in that respect?
No, it's not the most pleasant of topics, is it? But it does give you a lot of peace of mind. And
absolutely,
I guess from me, because I have done a lot of work in deceased estates, seeing the ones that didn't get the appropriate advice, didn't do the wills, didn't deal with things, how messy it can be, and just how much just heartache and a lot of aggravation and cost it causes. And then you see the ones where they planned ahead of time, and it just, obviously it's a sad moment for anyone dying, but to see the deceased estate run smoothly and everything go according to their plans, if people could see that side of things, they'd be doing it. They'd all be doing it.
And I guess going in the way that the deceased person wanted it to be, rather than how some legal interpretation of a law wants it to be.
Exactly. Yeah.
Okay.
So again, I just want to stress the point. It is often challenging, succession planning for farming families, but it's doable. It's well and truly doable. We've had a lot of great outcomes for a lot of farming families, but I think what you just need to bear in mind is that it's not going to happen overnight. So it just takes time to work through this process. You can't go in there with an expectation that after one meeting with perhaps the lawyer that you'll know exactly what the succession plan is going to look like. These things can take months to work through, and sometimes even years. But the point is, get started before it's too late, because I know I've got a client at the moment. He's in the late 70s and starting to get a bit of dementia, and a farmer, and to be honest, he has left it a little bit too late, because now everyone around him, his families, are scrambling, thinking we need to get something sorted. This could be a mess. There's a lot of assets at risk, and it would have been a much easier process if we had have perhaps done that 10 years earlier. So where to start first is, I guess, I think we've touched on this already, is get professional advice. If you want it done properly, get the professionals involved. It will probably take a team, particularly when we're talking about farming families. It's an accountant, it's a lawyer involved, might even be financial planner involved. But usually it's good. We like to work with the accountants. It's usually very much a team effort, because they have a lot of information about the business. They have usually had the long-standing relationship with the client, and they have probably got some good general views as well about a way forward. So with the accountant, then you need to get a lawyer who has experience in estate planning or succession planning. So that's key. But also you'll probably need a lawyer who has some experience in farming succession planning, because that is also quite different from just your normal run-of-the-mill succession planning. And it's usually that getting that professional advice just helps you to understand what's actually going to be possible. Because you might have some ideas in your head, but it's not until you actually sit down and discuss it that you realize that unfortunately that's not legally possible. But we can try make something else work that's going to give you a good result.
And one of the questions that's probably going through other people's minds at the moment, because it's certainly going through my mind, is, I'm going to be a bit old-fashioned here. I just want to flick open the yellow pages and choose a lawyer or choose an accountant or whatever. I guess the best thing to do is to talk to your brother or your neighbour or your sister or your auntie or someone who's been through this process and find someone that they trust, who by definition should mean that you would trust them as well.
Yeah, I think that's a really good point, Neil, because a lot of people do struggle to know where to go. And I would say that's exactly the way to go. Ask someone that you trust who they recommend. And if they recommend them, they're probably a good person to go to. I don't think it's a great idea doing a Google search or just going based off internet searches. I think you do need to know someone that has used them before and had a good experience. And yeah, look, I think the other thing is usually there's no problem with going with someone local either. Like, for example, if you're based in Ballarat, as a first port of call, try to find someone local. I do believe that is usually a better fit but sometimes you do need to go a little bit further, maybe to get the expertise. But look, yeah, that.
And I guess there's people who would say, I don't want, Sarah, who I play netball with, or, that I run along the beach with my dog with, because I don't want her knowing my personal stuff. So sometimes stepping away from the ones in a circumstance like this may make people feel more comfortable about the process.
Yeah, and that's personal choice as well. So it's who you gel with as well. There's nothing wrong with having an initial meeting, and if you're not really clicking with that advisor or thinking, I don't think they really get what I want, nothing wrong with it. Might take you one or two tries before you find someone you really like. Everyone's a bit different and different personalities.
And underlines the importance of getting started sooner rather than later, because if it does take 2 or 3 or 4 conversations, you could have wasted a year by that stage.
Yeah, exactly. So the next point to think about is about what are you trying to actually achieve. It will help if you've actually had a think about it before coming to see a lawyer and saying, well, help me with my succession planning. You need to understand what is it you want to achieve. You don't have to have it all decided, and also it might change over time as well. This could be an evolving thing. A lot of farming families and businesses, families and families in general, the succession plan is constantly evolving and revised and updated. So that's okay. It doesn't have to be set in stone, but if you have some idea, that's good. What's the ultimate thing you want to achieve? For a lot of farming families, it's this priority of maintaining the farm to keep that running. So if I died, it would a client might be heartbroken that the farm would have to be sold and no longer any family members working it anymore. So if that's the priority, that's good to know where we're starting. You might want to also think about when is it that you ultimately want to retire and hand over that management of the farm, and will that be going to the next generation, and who in the next generation is looking to step up and take it on. And that's where it can be tricky, depending on the family. There might be 3 children and one is showing signs that they want to take it on and be a farmer. Maybe there's 2 that want to do it. It can really depend on the family. And then also figuring out how you're going to provide for, if there are going to be children that are on farm, they're going to take on the farming business, what do we do about the children that are off farm, and how do we provide for them, and trying to make sure that there's going to be enough assets to provide for everybody. Sometimes that can be difficult. A lot of the assets are held but are farming assets, and so you sort of think, well, if we give everything to the son who wants to take over the farm, what are the two girls going to get? And I mean, that's a cliche. That's not happening as much anymore these days, but that's where the planning has to start early, so mum and dad can start thinking about, well, we need to start setting aside money, pushing aside investments that are not going to be for farm, that will be there for later down the track for the kids that don't go on farm.
I guess one of the other things too, from a farming family perspective, probably more so than any other type of business family, is the concept of multi-generational involvement, not just over history, but grandpa's still working the tractor and dad's doing this, and the young lady, the daughter is doing something else, and that multi-generational all being involved at the same time would add some complexity as well, I would have thought.
Yeah, it does. And that's where again, we often have to have other agreements to the side where the family have decided, okay, this is when we're going to step back. Mum and dad will step back, and that's when one of the kids can actually take control. So you don't have that messiness of, well, who's actually in charge now? And, the son that's holding out for years and years to be able to manage the farm. So I'll talk about that a little bit at the end about what are some other documents we can have that help sort of tie it all in. But the last thing was just this concept when we're thinking about providing for your kids, there's equal and there's fair, and it's not always possible to make it equal when we're dealing with farming families. It's very easy to make it equal if we're talking about a non-farming family and say, dad's died and it's just mum, she's got a house and bank account and she's got 3 kids and she dies. Those 3 kids just sell up those assets and divide it 3 ways equally. They have received an equal amount, a true equal amount. But for farming families, you're never going to get that. So it's about trying to get to something that's fair. So that's another thing we really, really talk about with family and help everyone kind of get their heads around that it's not going to be dollar for dollar.
Given that fair is a subjective measure rather than equal, which is an objective measure, who decides what's fair? Is that the family, or is there a legal definition of fair that comes in?
Well, there's 2, I guess. There's always in the back there, and there's the law of if you have an obligation to provide for someone, generally it's your obligation is to your spouse or to your children, whether they're adult children or dependents. And if you haven't provided for them adequately, there is always the ability for that person who feels hard done by, and this is in your will, I'm saying, if you haven't provided adequately for them, then they could potentially make a claim against your estate, and effectively what's known as contesting a will. So there is, in the eyes in the court, they look at that of what have you been provided for and is it fair? The court certainly doesn't say it has to be equal, dollar for dollar. But again, it depends on a range of factors, how much the value of the estate is and what that child's personal circumstances are like, whether they're financially well off in their own right or not. But the other point is we like to get to a point where the family, mum and dad and the kids, have all discussed the succession plan, and they all buy into it and believe that it's fair. So the whole, in a beautiful ideal world, the scenario will be with the succession plan, everyone knows what's happening and they think that it's fair.
And do they, let's say it's a farming family of 5, husband, wife, 3 kids. and they come to an agreement that, yes, this looks like a fair and equitable approach, do all 5 sign that agreement, or is it just the person involved who's going to pass away that signs it?
Yeah, so we get them to all sign up to it, and it's called a family constitution or a family agreement. And that's effectively a contract which you'll have sitting alongside the will that kind of ties it all together. Just the other point I wanted to make, I think we've spoken about it, but information gathering is really important. And usually it might take a few months to even get that completed. So when you meet with your lawyer, they'll want information not only about you, but about all the family members, who works on the farm, who works off the farm, what are the assets, as we said before, and basically what the best structure is for all of those assets. And there might be discussions at that point as well about transferring assets into different structures or into joint or sole ownership, and trying to avoid CGT and stamp duty where possible.
So it's never too late to create a different structure. For example, if we get to the stage we're having that conversation and it makes sense to set up a company, or it makes sense to set up a trust or whatever, you can do it at that point and then transfer assets. That's what you're saying.
Yeah, you can. Yeah.
Yep.
So that might be part of what comes, rolls out of what started as succession planning, might turn into further work to do some restructuring. The other one, is about communication, and we've sort of touched on this, but it's about talking to the family members and their expectations, needs, aspirations. So maybe previously, in earlier decades, it was more common for it to be quite a private matter when you were doing a succession plan. You did that with yourself or your partner, and you didn't really talk about it to your kids. These days, it's all about talking about it. And, once the kids are at an age, obviously not when they're little kids, but usually once they're like over 18, that's when you can start having discussions with them and start to bring them along on the journey with you. And sometimes as well, it's about trying to manage the family dynamics, because there might be siblings that don't get along, they don't talk, or there might be a child that's a bit troublesome, that is a little bit of a black sheep, and it's dealing with that as well.
Yes, and I'm sorry, I smiled. I may be accused of being that black sheep in my family, you understand. So,
are you? Okay.
Yes, indeed. So the first conversation that someone has with you would typically be the two partners coming in and saying, "Hey, Sarah, we need to do some succession planning here." Yeah.
So mum and dad would usually kick it off, and they might do quite a bit of work initially, and then once the succession plan has taken some shape, that's when we would encourage them to talk to their children about it. And then it might even be we schedule a family meeting to explain it all to them. And then, as we were talking about before, if there's a document like a family constitution or an agreement that sort of sets out everyone what the intention is for the overall transfer of the family assets or the farming assets, and we will get everyone to sign up to that. So that's quite a nice document to have that sits alongside the will. And it just, then that everyone has agreed to it, that they're comfortable with the succession plan and understand what's happening.
Now, you mentioned it, it's ideal to have this face-to-face. That's sometimes not practical. I believe you can actually even have video conversations where people are in different places at the same time. Sarah, I can't imagine how that works. So presumably, those sort of conversations with the family can be done online as well.
Yeah, all doable. And in this day and age, we understand family members are here, there, and everywhere. So it's not always possible to have the family all together in the one physical spot. But yeah, Zoom's made life a lot easier, and it's very easy now to communicate and just touch base with other family members.
Okay. Now, one area that I guess happens around 30% of the time is a situation where there's a blended family. I'm assuming that adds to even more to the complexity.
It does, because there's usually, you've got your assets, your partner's assets, you might have joint assets, and then you're both wanting to provide, if you've got children each from previous relationships, they all need to be provided for in some way. Again, it's blended families are very unique. Each one is unique, and you can't, there's not a one size fits all. It's really a matter of understanding a few different things. Firstly, in the eyes of the law, the spouse is your priority. You need to provide for your spouse the most. And then adult children and kids, obviously when they're under 18, but adult children are second. So when you're dealing with a blended family, everyone needs to kind of understand that. And also it's preferable if you have your own assets each, that you can sort of keep those separate, and maybe if you've both got a strategy that what's yours goes to your kids and what's hers goes to her kids, that's great. Again, it's best if you're on the same page and that succession planning is done together, so that you're sort of matching each other's, your wills are similar. But, and again, we'd sort of say if you want to talk about it with your kids as well, so they know what's going on, because probably the number one source of disputes is between blended families.
I suspect
we see in deceased estates, it's blended families.
Yeah, and I suspect it's got something to do with how long the family were blended before the deceased occurs. That if they've been in blended family for 10 days, it's going to be very different to 10 years or 15 or 20 or 30.
Yeah, and look, it all depends. There's a number of factors, but a lot of it depends on the length of the relationship. So obviously, the longer that the partnership's been, the more entitlement that spouse will have, as opposed to adult children. But and again, and then the size of the estate, if it's a large estate versus if it's a modest estate, there's also some strategies we can deal with. If you think you don't want a child making a claim, or vice versa, a spouse making a claim, you can do things such as looking at how you deal with your superannuation, whether that's paid to a spouse, to children, or to your estate, and then it's dealt with by your will. So there's a number of strategies. And again, looking at, well, who actually owns what? Do you own everything jointly? So if one of you dies, everything goes to the surviving spouse anyway? Or, again, it's one that needs to be really thought through.
Yeah, I guess also this question of, inequitableness, is that a word? Inequality, that's a good word, of assets brought to the relationship. I guess if you've got someone who's a millionaire who becomes involved in a relationship with someone who's virtually got nothing, how that balance works out and over time. And so that's, I think, a source of I think, did we mention earlier that every family is unique? I think. Yes,
that's the point, isn't it? That, again, I like something that I would always say is just bear in mind whenever you're getting into a relationship with someone and you have children, you need to think about that, because the longer that relationship goes on, there's going to be an entitlement to that spouse. Whether you're separate, whether you split up, there'll be a family law entitlement, or if you died, there'll be something there with your estate. So it's important. I think it can't ever hurt to just get some advice at the time where you stand, just to understand fully, because we've seen a lot of messy estates, basically blended families that haven't sort of done proper succession planning. Sometimes they've done no will at all, and it's just been a complete mess.
So we're getting close to the end of our time, and I will ask you some specific questions shortly, but I would have thought that, as you've mentioned the word evolving a few times, that if I was to rush in and see you next week and get my succession planning done for within the next 6 months, I don't just put it in a box somewhere and say, well, that's it, job done. I don't have to worry about it again. There's an ongoing requirement to review.
Yes, yeah. So we do say to clients maybe every 4 to 5 years, just have a look at your will and other documents and just check that they're still relevant. Another trigger point could be if something big in your life happens, a change in circumstances, someone dies, a divorce, or anything else, an illness, that's a good chance to just revisit your will and your other documents that you've got in place.
And some happy times, like the arrival of a grandchild, for example.
Yeah.
Or one of your own children getting married, for example. That would be happy times as well. We don't want everyone to go away now and be sad. So, Sarah, we are just about done on time, and you've just given so much great information. There'll be people who've got to this point, 55, 56 minutes into our conversation, and going, wow, where to from here? So what are the sort of top 3, 4, 5 things that people should do now to get their succession planning going?
Okay, well, I would say if you don't have a will, then you need to get one done, as well as in addition to that, we didn't touch on it today, but we'll talk about it later in some other modules, but powers of attorney. I think it's important to just make that appointment with a solicitor that is specialised in succession planning. But if you're needing that expertise in farming business, make sure you've got that too with that person. Get that started, and then they will take it from there, really. You'll also need to have a think about what you actually want. If you were to die, have a think, come up with some form of a little plan yourself, and then the solicitor can help you with that. But that's pretty much, I would be saying, get onto it. And if you've already got documents in place, then have a look at those. Get those out of the cupboard or wherever you've stored them, and check what do they actually say, because they could be 5, 10 years old or older and not exactly catering to what you need right now.
Absolutely. And one last question. We talked a bit about getting friends to recommend and so on. If for whatever reason people say, no, I want to go somewhere objective, is there a centralized, like the Law Society or somewhere like that, where people can go and check out a website or get some advice on finding a practitioner?
You could go onto the Law Institute of Victoria website, and they'll have a list, or they can help you with that. But yeah, look, I would strongly recommend you go by word of mouth of someone's recommendation, or a reputable firm.
Okay. Well, we have come to the end of our time. Sarah Murray from Mast Lawyers, thank you so much for providing so much amazing information for people. We should mention that Mast Lawyers can be found at www.mastlawyers.com.au. But with that, Sarah, thank you very much for your time.
Thanks for having me, Neil.
It's been
Pleasure.
Very informative. You've been watching and listening to a presentation called Farm Business Bites, an introduction to succession planning, featuring Sarah Murray from Mast Lawyers in Geelong. For more information about this program, please contact Partners in Ag. You can find out everything about Partners in Ag at www.partnersinag.org.au. My name's Neil Butler. Thanks for your company.